Good evening, friends. I, on behalf of Beyond Law CLC, welcome you all on a Sunday evening, which otherwise invariably one tends to relax. But we have found that during this endeavor of sharing the knowledge, it has also been the belief and motto that sharing is caring. So during these testing times, if the knowledge is shared through speakers who have immense knowledge, gives a different perspective to a weekend. And right to private defense, which is a vital right given to a person, we asked Honorable Mr. Justice M.L.Tahaliyani, who was a former judge of Bombay High Court and was recently demoted the office of Lokayukta, to give the insights. And as a judge of the High Court, as we have shared in our invite, he has dealt with several cases which not only hog the limelight of the news channels and social media. That is of the music baron Gulshan Kumar and the terror attack of 26/11 and Data Saman. So his insights on these aspects have a different perspective, which having knowledge being shared through such a person who is having knowledge will always give a thought process in the right mold. As they say, knowledge is always wheel within wheels. It keeps on improving as you listen to a good speaker, read good books. And today is a session wherein right to private defense, which we often speak about, not only as when we are students, but also as a lawyer. What are the spokes and what are the wheels, and how the mechanism within the criminal jurisprudence, etc., would move on. We have requested the Honorable Judge. Welcome, sir. And we are delighted to have you on the platform. Right, sir? Over to you.
Hello. Good evening to everybody. Friends.
So I will just check out. I think you're not audible. I can ask the participants. Yes, sir. Try it. Yes, sir. So you have muted yourself. Unmute. I'm just unmuting you.
Now?
Yes, sir.
Are you getting? Mr. Chaturbals? Is it okay now? Hello? Hello? Is it okay? Hello? Hello? Mr. Chaturbals?
Audible, sir. Audible.
Okay, okay.
Yes.
Hello. So friends, today we have assembled on this video link to discuss the right of private defense, which is available to the accused under Indian Penal Code, and the nature of right, restrictions imposed on the right of private defense, to what extent the right of private defense is available, is the provisions are contained in section 96 to 106. Now, right to private defense is a peculiar type of right where the accused himself claims that he had caused injury to defend himself or defend somebody else or defend his own property or defend somebody else's property. The right to private defense is available to defend oneself, to defend any other person from aggression, to defend one's own property, to defend somebody else's property. So right to private defense is available against the offenses against human body as well as the offenses against the property. Now, right to private defense is available in Indian Penal Code, under Indian Penal Code only in a particular circumstances when you don't have access to the law enforcing authorities and it is not possible to invoke that authority or call them, or they are not available at a short notice. In that event, there is an apprehension of danger to your life, danger to somebody else's life, or danger to property. In that event, you have been empowered, authorized by law to defend yourself or defend somebody else or defend your or somebody else's property. So this is as already said by me, this is available when the law enforcing authorities are not available. This right cannot be exercised as a pretense for attacking. Suppose the law enforcement authorities are available and they can be easily informed and they can reach the spot before the aggressor commit any mischief. In that event, this right cannot be exercised as a pretense for attacking him. There might be some other reasons, previous enmity or something, which the accused might retaliate in that, and thereafter he may raise the defense of private defense. So the defense of private defense is available in the under the restrictions under regulated law, and it is not a absolute right that you can do anything and everything at that moment. It is regulated by certain provisions contained in section 99, and within that particular area, we can exercise the right of private defense. Right of private defense, whether was available or not, is normally a question before the court whether the accused had caused injury to the complainant in his defense or in somebody else's defense, or whether the accused has caused murder in good faith exercise of right of private defense, is always a matter of fact to be determined by the court on the basis of facts and circumstances of each and every case. There cannot be any hard and fast straight-jacket formula to lay down that in these circumstances, the right of private defense is available, otherwise it is not available. The law is laid down, but the facts of the case will decide whether the particular case falls within particular the right of private defense or not, and whether it was regulated by a particular provision under section 99, and whether the accused had exceeded his right of private defense, and if he has exceeded, then in that event what could be the consequences of exercise of so-called right of private defense. So it is always a matter of fact, not matter of law, to be determined on the facts and circumstances of each case, the case before the court. Apart from this, the right of private defense, as already stated by me, is restricted by the provisions laid down in section 99 of Indian Penal Code. However, one thing is to be noted that court, while testing whether right of private defense was available or not, has to weigh the facts and circumstances for both the sides. There cannot be any golden scale to lay down that if this is the, weight this side, then this is available, otherwise not available. So as by me, it is a matter of fact and depends on facts and circumstances of each case. Court has always to bear in mind that when right of private defense is exercised, there are two possibilities. Either it was exercised in retaliation, or it was exercised in good faith, or it could be a case in between where good faith was there, right of private defense was exercised, but he had exceeded the limit available to the accused. The accused, if exceeds the limit which is available under law, then it will be the exercise of right of private defense in excess of the statutory provisions which make the said right available to you. Therefore, there cannot be any golden scale. Test is to be determined by the judge on the basis of facts and circumstances of the particular case. Now, the burden of right of private defense. Burden of right of private defense, because the right of private defense is raised by the accused always to defend himself from the punishment. So burden is always on the accused to establish that under this particular provision of law, the right of private defense was available to him and he has exercised his right within limits. He had not exceeded the limits available to him under the law. So burden is on the accused always. Now, how that burden is to be discharged by the accused during the course of trial? This is very, interesting that most of the lawyers I have seen during the course of my tenure as a judge, they don't take direct defense or private defense because it is sometimes detrimental to the interest of the accused. Even accused may not be ready to accept that. I will tell the judge, sir, I have done this. I have used the knife. I have stabbed the complainant, but I did it in my defense, or I did it in defense of my wife, or I did it in defense of my neighbor, or in defense of somebody else's property. So the right of private, the burden is to be discharged by the accused. Now it can be by direct statement made by the accused in the court under section 313, or accused can examine himself as a witness, defense witness, or he can examine any other person as a defense witness to discharge that burden. But if the accused or his lawyer does not want to directly put forth his case in this manner, then the right of private defense can be established through cross-examination of witnesses. The witnesses can be asked such certain questions to bring it on record that this happened, but in what circumstances the incident had occurred. The circumstances he can demonstrate before the court at the time of argument, that the circumstances which have come on record in the cross-examination clearly indicate that if at all the accused has done this act, it was done in private defense. So this is one way of doing it, by cross-examining the witnesses at the time of recording of evidence, or giving some answer at the time of recording of his statement under section 313 to just convey to the court his own feeling that if at all it was done in private defense. So this is how the burden of right of private defense is to be discharged by the accused. It is not necessary that it should be directly pleaded. It can be demonstrated by cross-examination. It can be demonstrated by the evidence of other witnesses. It can be demonstrated by the circumstances available in other pieces of evidence produced by the prosecution. Even with evidence of pancha witnesses who were present on the scene of offense at the time when Panchanama was done, that could help the accused. Forensic, the evidence can help the accused. So the accused can take defense and he can demonstrate on the basis of available record and evidence that it was in right of private defense. He is not supposed to take direct plea of right of private defense. Now the incidental question which may arise, whether he can take alternate plea of right of private defense and any other plea available to him. I did not. He can take the two parallel defenses. One is of total denial and one is of doing act in right of private defense. So he can, the law permits, there are Supreme Court judgments that the accused can take alternate plea, that there can be a case of total denial either, or alternatively it can be demonstrated to the court that it was an exercise of right of private defense. So at the time of arguments, the first leg of argument of the advocate would be to tell the court that I did not do it. But if at all it was done by my client, it was done in exercise of right of private defense. So, and if the right of private defense is exceeded, then the question of punishment will, it is exceeded absolutely, then that will not be available to him. But there are certain cases where if the right of private defense is exceeded, then in that case, the quantum of punishment and the section under which the accused is to be convicted may change. Take for instance, the offense of murder, 302. Now, that is culpable homicide and murder, these are two things. Now, murder is punishable under section 302 and culpable homicide is punishable under section 304. There are some exceptions under section 300 which lay down that if the death is caused in this particular circumstances like sudden provocation and all these things, then it may not amount to murder, it may amount to culpable homicide, not amounting to murder, which may invite a lesser punishment. So exception 2 of section 300 lays down that if the accused has exercised right of private defense in good faith, but had exceeded it, then in that event, the murder may be culpable homicide and not murder. It will be culpable homicide not amounting to murder, which will not be punishable under section 302 of IPC, where the minimum punishment is life imprisonment and maximum punishment is death penalty. So he may demonstrate to the court that his case falls under culpable homicide, thereby he can pray for lesser punishment for culpable homicide not amounting to murder. So this is the scope of this right of private defense in general. As I told you, alternate plea can be taken. Now, at what stage plea can be taken? Plea of right of defense, the defense, at what stage you can raise the defense? First of all, at the time of trial, obviously you can raise the defense. During the course of cross-examination, you can try to develop your defense. During the course of recording of statement under section 313, the accused can develop his case. And at the time of argument, he can demonstrate to the court on the basis of evidence of prosecution itself and the cross-examination that there is a case of right of private defense. Secondly, whether he can take this plea in the appeal. Now, suppose that plea was not taken at all before the trial court. I acted in right of private defense. And there is no record in the trial court's judgment that this plea was ever raised and was rejected by the trial court. Now, whether the appellate court can entertain that plea of right of private defense in appeal, the appellate court can always entertain that plea, though it was not raised before the trial court. As I told you, it is a very delicate, defense, which sometimes due to the innocence of accused or due to the reluctance of the accused or due to the reluctance of the advocate, it is not taken. But when the matter comes before the appellate court, the appellate lawyer feels that there are circumstances in this case where the plea of right of private defense should have been raised, but it was not raised. So the appellate court can consider it. Even appellate court can consider and say, the right of private defense was available to the accused. Though it was not raised in the trial court, it can be raised here. And I feel that this is a case where right of private defense was exercised by the accused at the time of the assault. So the stage in appellate court also, the right of private defense can be raised. Burden of proof, as already I told you. Now, whether the right of private defense is available in free fighting. Suppose the free fighting is going on between two persons or two groups. They can take right of private defense. both the parties are determined to fight, and it is very difficult to decide who is the aggressor. In that event, to my mind, the right of private defense may not be available. Take a case of unlawful assembly. There is unlawful assembly, as we know that unlawful assembly is always of more than 5 persons, 5 or more than 5 persons. An unlawful assembly of few persons attacks the other side, and they are 2-3 persons, and gradually that other side also, few people come together and they become more than 5. Now there are 2 assemblies, one of this side, one of that side, and there is riots, there is fighting. Now in that event, whether the other side which was attacked, whether the other side, receiving side, can raise the plea of private defense. Now the aggressors had already formed an unlawful assembly to commit an offense or to commit an act by illegal means to defend the force used by unlawful assembly or force likely to be used by unlawful assembly. The other side persons gathered, and they were also more than 5, and they retaliated. They retaliated because they were apprehending danger to their life, or they were apprehending danger to their property. The assembly of more than 5 persons had entered the field and they were destroying the crop of other side. So to save the ready crop, the other side defended their property and caused some injury to the persons of members of unlawful assembly who had entered their field. In that event, you see, the court can consider that plea, and court can give a finding on that, whether the right of private defense was available or not. Now, in that case, whether the right of private defense was properly exercised or it was exercised as a pretense, that court will have to be decided on the basis of the facts available on record. But there is no bar in such cases to entertain the right of private defense. This plea can be raised by the accused or his lawyer, as I told you. Sometimes reluctance is the cause that this plea is not taken. If there is so much of reluctance, then this can be taken in the cross-examination. This can be demonstrated from the evidence on record, not by directly pleading that I did it in right of private defense. So, how the burden is to be discharged, in what circumstances the right of private defense is available, in what circumstances it is available in free fighting, in unlawful assembly. There are so many cases that you can go on, but ultimately the right of private defense is a matter of fact. It is to be determined on the basis of facts available on the record. The right of private defense is a shield given to the, as I told you, when you can use it when the law enforcing authority is not available, or it is very difficult to call them. It is very difficult to get help of the police. In that event, you can exercise the force against the aggressor. You cannot exercise the force if the police station is at stone's throw. If the police station is a 2 minutes walking distance, you can just rush to the police station instead of rushing to the aggressor. You don't go to police station, but you rush to the aggressor, then in that event, the case may become difficult for the accused. So this is available when there is no other protection available to the accused, and accused has to use force. So this is a shield. This is not a sword. If you use it as a sword, then I think the right may not be accepted by the court. The plea may not be accepted by the court. Court may reject it. But if you use it really as a shield to protect yourself, to protect somebody else, to protect your property or protect somebody else's property, then definitely the plea will be entertained by the court, and court will decide whether your plea is genuine or it is a pretense. So as repeatedly said, this is available in very exceptional circumstances. It is to be used as a shield. It is not to be used as a sword. Now let us go to the provisions of IPC, under which the right of private defense is available to the accused. The right of private defense is available from section 96 to 106. Now, section 96 says that things done in private defense are not offense. Nothing is an offense which is done in the exercise of right of private defense. Now, if we read this bare section, and if we don't read the succeeding sections, then it gives a picture that you can do anything in right of private defense. But that is not so. That is regulated by section 99 of IPC. To what extent you can use this. Nothing is an offense which is done in right of private defense. Now, what is right of private defense? As repeatedly told by me, it is right to defend yourself, right to defend somebody else, right to defend your own or somebody else's property. Now, right to private defense of body and property. This has been explained to me, explained by me, and I need not read section 97 again, because I have in introductory portion, I have explained to you what is right of private defense. And that is the same thing which is stated in section 97 of IPC. Right to private defense 98, I think is not necessary to be discussed in this meeting. Let us go directly to the to section 99. Acts against which right of private defense is not available. Now, if the act is committed by a public servant, 99 says that if the act is committed by a public servant or under the direction of public servant, in that event, right of private defense is not available when there is no reasonable apprehension of death or grievous hurt. If there is reasonable apprehension of a simple hurt, and the force using authority is a public authority like a police, you know that he cannot use force. He is not allowed to use force. You know that he is a police officer. But so long as there is no apprehension of death or grievous hurt, you cannot use force against the police. The action taken by police was right or wrong, that will be decided later on. So the condition precedent is that to use force against the public authority is that there should be apprehension of death or grievous hurt. If there is a reasonable apprehension of death or grievous hurt, then you can use force against the police. Secondly, you must know or you must have a knowledge that he is a police officer or he is a public authority who can use the force. If you don't have knowledge that the force using authority or the aggressor is a public authority, in that event, the right of private defense is available to as if it is available to any other member of public. But once it is established that you knew that he was a police officer, you did not have apprehension of death, you did not have apprehension of grievous hurt. In that event, even if the act of public authority is unlawful, you in normal course is not entitled to raise the plea of private defense, because the simple hurt, the issue can be taken at a later stage. The public authority can be punished for that if he has done anything in excess. But once you are apprehending danger to your life or you are apprehending grievous hurt, then you can exercise right of private defense against the public authority also. But if you don't know that he is a public authority, you can exercise right of private defense in the case of simple injury also. So the knowledge that he is a public authority is very important. Secondly, apprehension of death or life imprisonment is also a very important factor in this case. Now, section 99 further states, the right of private defense in no case extends to the inflicting of more harm than it is necessary. Now, this is very important. This is the crux of full right of private defense. How much injury you can cause, how much force you can use to defend yourself from the aggressor. How much force you can use. The force which you are using or attempting to use should not be more than necessary to defend yourself. because you are not allowed to use force to kill him or to cause grievous hurt to him, even though it is not necessary. The right is given to you to defend yourself. If you exercise the force or right beyond the necessity, then I think the right of private defense plea will not be accepted, because you exceeded. Once you know that now the apprehension is over, then you have to stop there. Take a case of an old man is being attacked by somebody by means of a stick, what we call lathi. And he was sitting in his courtyard. He calls his son, save me, take care of this man, he is attacking me. His son brings up this kitchen knife, vegetable cutting knife, and inflicts one injury on the aggressor. He stops the lathi attack. Your purpose is served. You can't go beyond that. If the person of the old man goes beyond that, if he tries to inflict one more injury or he inflicts one more injury by means of same knife in the course of same transaction, then the second injury will not be a permissible attack. Because once the one injury is caused and the attacker has stopped inflicting lathi blows on the old man, your purpose of defending your father is over. Your right of private defense has ceased to exist thereafter. And if you do anything thereafter, that is an excess of the right available to you. And that then will not be entertained by the court as a right of private defense. And if due to second injury he dies, then it will be 302 will be registered. At the most, in that 302 trial, this man can take a plea that in good faith he exercised right of private defense, but he exceeded it. Therefore, his case falls under exception 2 of 300, and he may be convicted for culpable homicide not amounting to murder. But he cannot get the complete exoneration from the crime. So these are the limits imposed by the law under right over right of private defense. Now, when a right of private defense can extend to causing death, can extend to the causing death of other person. Right of private defense of body extend under restrictions mentioned in the last preceding section to the voluntary causing death, when first there should be apprehension of death, there should be existence of apprehension of death, and you should apprehend that if you don't exercise your right and if you don't cause death of the other person, he will cause your death or he will cause somebody else's death. The apprehension of immediate death may entitle you to cause the aggressor's death. So death can be caused in these circumstances when there is imminent danger of you suffering death or somebody else suffering death due to the aggression. Then the aggressor can be killed by you, and that will be no offense. That will be a case of clear acquittal, not even culpable homicide. Because it is permitted under section 100 that when there is apprehension of death, the defending person can go to the extent of causing death of the aggressor. The second is grievous hurt. Similar, if the immediate apprehension of grievous hurt is there, the defender can go to the extent of causing death. But if he can cause less than that and the death was not necessary, then he may not be permitted to cause death. But if he causes death because there are circumstances, unless he causes death, he will not save himself from the grievous hurt. Now, grievous hurt may be of nature that ultimately he may die also, we don't know. Therefore, this authority, this entitlement is there to cause death of the aggressor in that event. And thirdly, when there is assault of committing rape, the accused of rape can face this death if the defender want to save the victim from rape. The defender want to save the victim lady from rape. in that event he can go to the extent of exercising right of private defense, means to right to save that lady, and in that event he may even go to the extent of causing death of the person who was attempting to rape the victim. Fourthly, that is similar, it is in respect of gratifying unnatural lust. Instead of rape, in this section it is gratifying unnatural lust. And fifthly, kidnapping or attempting. There is an assault with an intention to kidnap or abduct. Now, unless you cause death of the abductor or kidnapper, it will not be possible to save the victim from being kidnapped or abducted. If these are the circumstances, then if the death is caused of the aggressor, then it will not be an offense because that is permissible under law. Sixth is wrongful confinement of a person under such circumstances which may reasonably cause apprehension that unless he can have recourse to the public authority, the person who is wrongfully confined cannot be saved. Now, if there is no recourse to the public authority immediately, and person is called confined under circumstances which may reasonably cause him to apprehend that he will be unable to have. Now, the person who has been confined will not be able to get help of the law enforcing authorities, and you are there. In that event, the defender can use force against the aggressors to cause death. So this is section 100, which says when the right of private defense of body extend to causing of death. So this is very, very delicate situation in this. When the defense is taken under 100, the judge has to be very, very careful, because taking this defense is very easy, but appreciating the evidence to prove that defense is a delicate part which judge has to handle at the time of the pronouncing the judgment. The facts are to be evaluated properly. Otherwise, there are two possibilities. One, that wrong plea may give acquittal to the person. Second is that the rightful plea may not be entertained and the person may go to jail. So this is to be when the case falls under section 100, the judge has to be very, very careful. At the same time, the defense lawyer has always, of course, the defense lawyer and prosecutor both are officers of the court. They have to assist the court in a very able manner when such a delicate situation arises under section 100 of the IPC. Now, section 101 is that when you can cause harm other than death. When the offense which is likely to be committed or which is being committed in front of you does not fall under any of the offenses enumerated in section 100, then in that event, the right of private defense is available to cause harm to the aggressor, other than death. Right to cause death in private defense is available under section 100 only for 7 type of cases, which is one of asset administration is also there, which I could not read. So 7 type of cases are covered by section 100. Any other case which is not covered by section 100 will fall under section 111. In that event, the defender can cause grievous hurt, any other harm, maybe grievous hurt, simple hurt, but he cannot cause death. If he causes death, then it will be exceeding the right of private defense available to the defender. Thereafter, 102 is very important. When right of private defense commences and when it ends. The right of private defense in 2 situations is available. One is to save human body, other is to save property. Now, when this commences and when this ends, This is very important at the time of evaluation of evidence. If the right of private defense has commenced and it has ended at particular time, and thereafter suppose defender attacks the aggressor, then it will not be exercise of right of private defense, it will be exceeding the limit of private defense. Now in a case of theft, suppose the thief has come, he has taken away the property and he is running away. So you cannot chase him. The defender cannot chase him and cause injury to the accused to retrieve the property. Or the property has already been retrieved by you and the thief is running away by throwing your property. The thief took away your mobile phone, but you chased him and you could retrieve your mobile phone from him. Thereafter, you can catch hold of him yourself or with the help of others available on the spot, and you can take him to police station. You cannot attack him. And during that attack, if he receives some injury, I think the defender would be committing the offense of causing that injury voluntarily, whether it is simple or grievous hurt or death. Because right of private defense is given to the defender to save the property. Once the property is saved, the right ceases to exist. You cannot exercise that right. Then other remedies are available, that you go to the police station. If you cannot catch him, you go to the police station, tell the police, this has happened, I could retrieve my phone, but this man has escaped. So police will register the FIR and police will trace him. You don't go beyond that. In the case of robbery, dacoity also, once that apprehension of causing harm, causing death is over, then thereafter the right of private defense is not available. Right of private defense is available to defend. Once it is known that you have defended yourself, your property, you have defended yourself, then in retaliation you cannot do it. He was taking away my phone, therefore I assaulted him. This, and I caused grievous. Suppose in the case of mobile phone, I told you, after retrieving mobile phone, if the owner of mobile phone attacks the thief and causes fracture, to my mind, the telephone mobile owner will be prosecuted for causing grievous hurt under section 325 of IPC, depending upon what weapon he had used. It could be even 326 of IPC also. So once the apprehension is over, the right also ceases to exist. Then thereafter we cannot use, because it is a shield, it is not a sword. Once a shield is not needed, attack is over, you cannot run behind the attacker and cause his death or cause injury to him. This is applicable in both cases, whether it is defending yourself or somebody else, or defending your property or somebody else's property. The crux of the matter, we can read the section as a whole, but ultimately, after reading the sections in respect of the commencement and conclusion of right of private defense, you will come to the conclusion that crux of the matter is the right of private defense is available till the time the apprehension is there. Once that apprehension is over, the right ceases to exist. Or offense is committed and he has run away. Property is taken away. You cannot run behind him and cause injury. You can run behind him to retrieve the phone. But in that process, there is a thin line between that. Now, one may take a defense case, unless I would have attacked him, I could not have, retrieved my phone. Therefore, I chased him, I attacked him and I retrieved my phone. Now, this may depend upon the facts of the case. In that event, whether you should have gone to the police station or you should have chased him and attacked him. Because law does not permit a police officer to chase the accused and attack him. The law permits the police officer to chase the accused and catch him. So this is the situation. In all cases of right of private defense, the judge is faced with very, very delicate situation. And evaluation of evidence is a very difficult task which judge has to do. And lawyer and prosecutor both are under obligation to help the judge to present the facts before the judge, to enable him to appreciate the evidence whether right of private defense was available or not. If it was available, whether it was exceeded or not. If it was exceeded, it was fully exceeded, then the punishment will follow. Whether the right of private defense exceeded under exception 2 of 300, then it will be offense under 304, punishable under 304 of IPC. I think I have covered generally the right of private defense available to the defender to defend his himself or somebody else, his property or somebody else's property. Now I think if there are few questions and answers, we can take up the questions and answers. The issues which have remained unanswered in this speech, they can be answered. And if you want, I can further elaborate the commencement and conclusion of the right of private defense. Depends upon you, whatever you want. We can elaborate the commencement and conclusion, or we can have the questions and question answer session. Yes, Mr. Chaturvedi. Yes, Mr. Chaturvedi. Hello, hello, yes. Mr. Vikas. Mr. Vikas, are you getting me? Yes, Mr. Vikas. Shall I continue or there will be question answer session? No, I am not getting you. Microphone.
Yes, sir. So till now, I will just check it on the Facebook. If questions have come on this group, nobody has at least posted.
Then I'll continue with this and we will conclude within 15 minutes.
One question has come meanwhile. What evidence can we give as far as section 100 and 101 are concerned?
What evidence
we can give as far as section 100 and 101 are concerned?
100 and
101, both.
What evidence can be given by the
can be given in terms of section 100 and 101? Could you share some experience on that?
Okay. Now, 100 is causing death and 101 is causing any other harm. I'll give you one example which may fall under section 100. Now, there was a field of two very close relatives and there was a common boundary between two fields. But there was a dispute regarding the common boundary. Now the accused who claimed right of private defense was owner of a part of the field, and accused B was the person who was killed. The deceased was owner of part B. Now A has caused death of B. A faced trial before me under section 302 of IPC for causing death of B. Now the incident happened in the manner that A had already gone to the field with an axe on his shoulder. Now in our area, in Nagpur area, most of the agriculturists, they carry axe on their shoulder when they go to the field. So the B also came with an axe in his own field. But A had an information that B was cutting the crop which was sown and grown by A. So on the other end of A's field, this activity was going on. So A went there and A wanted to stop the B and his companions from being destroying his crop. But B did not listen, and B, you see, become little aggressive. This field belongs to us, and this crop belongs to us. You cannot stop us from cutting the crop. We are cutting our own crop. You cannot do anything. So this happened. This went on for a very few minutes, and ultimately, what happened? In the exchange of words, B raised axe over A, and A, what A did, A also raised axe, and actually he inflicted a blow on B, and B died. A was facing trial for offense of murder. His plea of private defense was rejected by the trial court. His case came up before the High Court in appeal, of which I was one of the members of the bench which heard the appeal, and the judgment was written by me. The matter was argued at length by a very senior counsel at Nagpur bench, and the lawyer tried to demonstrate that it was in right of private defense. So there was multiple pleas that right of private defense was right to defend property and right to defend himself. Now the delicate question which arose when the B raised axe, whether A was justified in inflicting blow of axe on B on vital part of his body, which resulted in death. One blow of axe resulted in death. Now, whether the right to cause death under section 100 was available to A. This was the question. Now, after evaluation of evidence, I came to the conclusion that the evidence disclosed that B had raised axe. Actually, the blow was not about to be inflicted on A. There was no evidence that B was about to inflict the blow, and to ward off that blow, A also raised the axe, and he just in a right of private defense inflicted blow on B. The evidence disclosed that demonstrated clearly that B had only raised the axe. Sometimes we threatened, "मैं थप्पड़ मार दूंगा, आगे मत बढ़ना." But there was no further action on the part of B, which may demonstrate that he was just about to inflict a blow on A. Therefore, I took a view that the right of private defense was not available to that extent, causing death. Right of private defense was available to A to save his crop as well as to himself. But the right of private defense was exceeded by A. A was not, A was not entitled to inflict a blow on vital part of B's body, which resulted in instant death. Therefore, in this circumstances, the evidence which the B was supposed to bring before the court to take defense under section 100 of complete acquittal, the evidence was needed to show that had I not inflicted a blow on B, B would have definitely caused my death. There was no other, option available to A. There was no evidence to show that had A not used the axe, the B would have definitely caused death of A. There was no such evidence. And if such evidence was not available, I took a view that the right of private defense was exceeded. And therefore, he was given benefit of exception 2 of section 300 of IPC, and he was convicted under section 304 of IPC and was sentenced to undergo punishment which he has already undergone. He had undergone 7 years. So he was released after a day or two with a payment of some fine. Any other question?
Yes, sir. Here, what would be the circumstances where A would be justified, according to you?
Yes, I could not follow.
So I will just take the question. If a thief comes to my to a home, and while stealing, the person I wanted to attack him with stick, but he suddenly sees me, and in right of private defense, he harmed me. So can the thief take the right of private defense against
No,
me?
he cannot. He cannot. He cannot take the right of private defense because he is the aggressor. Right of private defense is given to you to defend yourself. If a person goes to commit theft, a person goes to commit robbery, he enters the house means he has committed the offense of house trespass also. If he has committed trespass in the night, he has committed the offense of criminal trespass in the night. So it amounts to criminal trespass plus theft. A person who himself is trespasser in the night and is committing theft, and if the defender is defending himself, in that event, you see how can that thief can take right of private defense? He cannot. That is not available to him. Right of private defense is available to the person whose property is being stolen. He can use some force against that thief to save his property. But if the thief runs away with the property, then in that event, that right of private defense available to the owner of the property also ceases to exist. He can go to the police station or he can make a police phone call that my property this particular mobile phone has been taken away or my cash has been taken away 5 minutes ago or 10 minutes ago. He cannot just take few people and go chase him in a car and then attack him or kill him. This is not permissible. But as far as accused who is the thief, he cannot have a right of private defense. How can he have a right of private defense? These facts which you are explaining to me, I don't think that the thief had any right of private defense.
So this is by Azad saying, whether a person can take a plea of self-defense and plea of alibi as an alternative in his defense. What is your take?
He can take, but these two pleas will be difficult to be entertained by the court. But these two pleas are not consistent. He can take. There is no harm. There is no bar. He can take. But the plea of alibi and plea of right of private defense are two contradictory and very inconsistent pleas, because when you take a plea of right of private defense, you admit your presence on the scene of offense. And if you take plea of alibi, you deny absolutely the presence on the scene of offense. But there may be a case where you see both the pleas can be taken, but hardly you could find a case where these two contradictory or inconsistent pleas can be taken.
So this is by Advocate Wahid Sheikh. A person walking on the road, suddenly B accused came and started stabbing to that person, and subsequently C saw that and he tries to intervene, but he also sustains injury, and finally he had taken his defense so as the right of private defense. As to whether right of private defense will come into being.
No, who has taken?
Just
B.
C.
No, who did the right of private
Subsequent
defense?
C saw and he tries to intervene, but he also sustains injury, and finally he had taken the defense. I suppose it's C, because that question is that way.
The C is prosecuted, but C sustained the injury, no?
Yes, sir. And he says that whether C can take the defense, who the attacks, A is attacking B, B is being attacked by A, and C sees it and C attacks him, but again the A attacks him. So whether C can take the defense. I will just read the question. I will read the question again. It says, a person, A is a person walking on the road. Suddenly B accused came and started stabbing onto that person.
Yeah.
And subsequently C saw and he tries to intervene, but he also sustains injury, and finally he had taken his defense.
Okay. Who attacks? A or B?
A person is walking. It should be B, because ultimately C is trying to defend A. Now, whether C can take the defense of private defense, I don't know the question.
C was prosecuted for what? That is the question before me.
Sir, I believe these are all presumptive questions. I would rather believe that you can share 2-3 cases which you found interesting, and what was the defense and how the things moved forward. Because they are all coming with A and C. They are not actually coming out with the actual questions. So rather your personal experience where it was taken up and how you found that imprudent, or how that plea taken but not considered by the court? I would rather, we would all cherish that.
I gave you one incident where the plea was rejected by me. I took the view that the right of private defense was accepted, and therefore the benefit of exception 2 was given to the accused. Now, I had I had a case in High Court, which was single bench, because it was not a case of murder or which could be heard by the division bench. I remember the facts of that case. In that case, there was a clear case of assault on the part of accused. It was voluntarily causing grievous hurt. There was a clear case of assault, and the accused took plea of private defense. There was no evidence at all to show that there was any aggression on the part of the person who was injured, or who did anything of the nature which may cause serious apprehension in the mind of the accused to cause grievous hurt to the complainant. So, unless there is evidence of aggression, nothing can be done. The plea of defense, this was a case of, I think, vegetable vendor selling vegetables with a knife in his hand, I think. And somebody had come to his shop, and there was some altercation, some exchange of words between the customer and the vegetable vendor. Now, vegetable vendor was accused in this case for the charge of causing grievous hurt by means of knife, because he had assaulted the customer by means of knife which he had kept for cutting vegetables. Like green vegetables are sometimes cut, or some vegetables are which are cut and sold. So knife is always available in the vegetable vendor's shop. So he used that knife and he attacked the customer. The customer sustained grievous hurt. Since the knife is weapon for cutting, so the case did not fall under section 325, but 326, and he was convicted by the trial court. Now, plea was taken before me, not before the trial court. Plea was taken in appellate court. As I told you, the plea can be entertained by the appellate court also. So I entertained his plea. I heard him on that point. But I told the lawyer, can you please show me in the evidence that the complainant, the customer, in any manner had aggression, or he aggressively did anything of the nature which caused apprehension in the mind of vegetable vendor that something will happen if he doesn't use the knife. Now show me evidence. The lawyer was not able to show any evidence on the record. There was only altercation of exchange of hot words between both the parties, and in that, you see, and there was no even there were no circumstances to show that there was any sudden provocation or of anything of that nature. So he can get benefit of some other provision. So in such circumstances, as I told you, apprehension is the basic thing. Unless there is apprehension, you cannot use the right of private defense. Right of private defense is not retaliation. Right of private defense is not sold. Right of private defense cannot be used as a pretense to commit injury. Now, if the vegetable vendor had already an enmity with the customer, he was his usual customer coming there, there was something between both of them which you don't know, which has not come on the record. And if he had used this incident to cause knife injury, and thereafter he takes the defense of plea of right of private defense, that will not be entertained. He has to demonstrate the apprehension, because apprehension is the basic thing in exercising the right of private defense. So his plea was turned down. I gave him some relief in the sentence, I believe, on the same conviction, but I did not change the nature of conviction.
Yes.
Any other question is there?
Sir, questions are not there you would like to share, because one of the aspects which invariably comes that when there is a lot of media glare and media watching the cases,
Good.
like we were examining in your particular case that you had dealt with the music baron Gulshan Kumar, then terror attack and Lata Samant. What is your personal experience? How does it actually work, and how does it actually, one has to come across that and see that the justice is not only done but must be seen to be done?
It causes pain to a judge like me, I tell you. Too much of media coverage causes severe pain to us when the trial is going on and some opinions are expressed in the public and they are, you see, available, you see, on the television and all this media, electronic media and print media. It causes a lot of pain, but we are not supposed to be influenced by that. When the case of this Gulshan Kumar murder was going on, there were 18 accused in that case. Only one was convicted. 16 were released on bail just few days before the judgment was delivered, because I evaluated the evidence, I felt that these people are not required to be detained in prison. We'll see later on. Only 3 persons were detained in jail until the conclusion of trial, and one was convicted of 3. So one day when I was returning home, I had reached home, and after a few minutes, I left home for evening walk on Marine Drive. So when I was walking on Marine Drive, I saw that there was a camera and some lights and all these things. So I proceeded further, and I saw that a lawyer connected with that case was giving interview to the media persons with regard to the facts of that case. So I avoided to go to that side, because I felt that by mistake, even if the camera catches me, that will come on the television that I was also passing by the side of that advocate who was giving his interview. So that I avoided. But I tell you, as far as lawyers are concerned, what happened in the court, telling the media is nothing wrong in that. What happened in the court, because the media persons, everything they cannot cover. Sometimes you see they are not in the court. So telling the media what happened in the court factually is not wrong. But expressing any opinions and all these things sometimes is detrimental to the interest of the parties. But as far as a judge, I would say I have faced many situations. In fact, 2611 case where that Kasab was tried and convicted. There was no public except media. Daily, my court was full of media persons, and when the judgment was delivered by me, my court was full of about 150 media persons, national and international. So normally, I myself, I can tell you for me that I had never, succumbed to any type of, discussions and all these things. And I always went by the evidence on record. And that every judge normally does. But you cannot, in this democratic country, and right of speech, constitutional rights are available. So you cannot lay down any definite limit to that. But as far as possible, if everybody exercises restraint which is necessary and doesn't go beyond that, I think that will be the interest of administration of justice. I know.
And so, since you have discussed 2, now the 3rd is left. What was your experience during the Datta Samant's case? Because people like us, while being in Punjab, Haryana, Datta Samant was a towering personality. He had his own following, the leader of his own class. So what was your experience during those times of that particular case?
During those times, you see, Datta Samant was a towering, union leader, and no doubt. But I tell you one thing of that case, that the conviction was arrived at by me, not on the, of course, on the basis of evidence, but there was one very peculiar thing in the evidence, which was left unnoticed by both the parties, and it was noticed by me, and it was a cementing force to, convict the accused. And in that case, there was no media role. I did not stop any media person to enter my court.
And that time, the media wasn't to that level also.
Now, those days, electronic media was not very much like this. Today, you have number of channels which you can't count. You don't know how many channels are available on your television set-top box or what. You don't know. At time, you see, the media channels were very limited. Most of the issues were covered by the print media. and they were very restricted and were very disciplined. I did not have any problem with the media at that time, and the case went on very smoothly, and it was concluded. There was media glare in the case of this Gulshan Kumar, because he belonged to the film industry. Therefore, the media was more interested in that case. They used to come daily in my court, and daily there used to be the cameras outside the court. You see, in front of gate of the Sessions Court, Bombay. So, but that did not make any difference to me. I went on. I had a very smooth period, smooth trial. No issues with the media at all. I did not have any occasion to, you see, scold any media person. Not at all. Not at all. Even in the trial of 2611, I did not have any difficulty with media persons. They were very disciplined. Sometimes they used to exceed there, because after it is media, it is not judgment of the court. So you have to give them some concession, which I always used to give them. I never used to bother about them, because it is meant for public. It is not meant for, it is not part of evidence. So we have to give some concession, and we have to forget it.
So what, according to you, would be the Lakshman Rekha to be drawn by the media and
Hello,
the lawyers?
Hello, I could not. Please repeat it.
I said, what could be the Lakshman Rekha, according to you, that the media should adopt, the lawyers should adopt, so that the fair trial in the right perspective can move forward?
There cannot be any definite Lakshman Rekha, but as I told you, some restraint would be good in this unnecessarily making comment on the basis of some facts gathered from here and there, which are not part of the record of the investigation. You see, because people who sit in front of TV are not always lawyers, and normally lawyers don't sit too much hearing all these news. The laymen are more. So when you are traveling somewhere and somebody comes to know that you are a judge, you will face so many questions on these issues. So laymen, they sit before the TV and they draw their own conclusion on the basis of television discussions and the news, and the way the news is told by the media persons. So they carry their own views, and those views are based on news, because they don't know the law. Sometimes what is stated in the electronic media or in the print media may not be in accordance with the law. But you see, the layman doesn't know that. So he is sometimes carried away. It doesn't make any difference. It will go on. It goes on not in India, but it goes on in other countries also. So you cannot stop it. But as far as the persons concerned are there in that, I said that reasonable restraint is necessary, and it will be good for everybody, for media, for judiciary, for lawyers, and it will help the system to do the justice. And otherwise also, justice, I don't think, is affected by all these things. Justice takes its course according to law, and there is no problem.
So I would be just saying, we had one of the webinars from Bombay itself, speaking on media trial safeguards of accused by Abad Ponda.
Abad Ponda, yeah.
Yeah, he spoke very well on the media trial safeguards of the accused. He gave the different
facets. You see, he can speak because he's a lawyer, but as I am a retired judge, I have to restrain myself while speaking to you on this subject.
No, that's true. That's true. But we just wanted to have a first-hand information as to what is the effect, and your candid expressions are actually would be quite insightful, and we are quite thankful to you for giving us the insights. And the way on the chat box we are seeing on as well on the Facebook, people are just happy to the way you have shared your experience as well as the knowledge. It gives a different flip on a Sunday. To have knowledge as well as the first-hand information, which invariably everybody wants to know about it. So thank you to all those participants, those who have connected with us on the platform, as well as on the Facebook. Do stay connected with us. Tomorrow at 4 p.m., since it's a weekday, on weekdays, we invariably do our webinars at 4 p.m. Tomorrow, Justice K.T. Sankaran, former judge, would be giving us the insights on the adverse possessions, the overview. Do stay connected with us. Those who want to see watch our previous webinars, we have uploaded on the YouTube channel of Beyond Law CLC. You can subscribe, share, and like that channel so that you can get all the links. Today's webinar would also be uploaded on the YouTube channel, though we are already live on the Facebook. But YouTube, you can watch it any point of time. Thank you to everyone, and especially to Sir. Namaskar, and Sir, it was quite insightful session from your side, and it will be help to see the right to defense in the right manner, the right perspectives, and the way you told that the judges don't get boggled down by the way media is connected, and that's why they say that the heart is on the left, but you always think right. So on this right note, on the right of defense, we all move on forward for watching the webinars for tomorrow. Thank you, everyone. Stay safe, stay blessed. Thank you.
Thank you.